Hi everyone, so in this video we are going to cover another new chapter, that is Lokpal, and this is going to be last body in series of our discussion on extra constitutional bodies that we had started around 15 or 20 days back. So as part of our discussion on extra constitutional bodies, so far we already have delivered lectures on NHRC, SHRC, Niti Aayog, this Planning Commission, then Central Information Commission, State Information Commission, Central Vigilance Commission, CBI. So all these bodies as part of our discussion on extra constitutional bodies has been delivered. I know from Lakshmikant's 6th edition point of view, there would be few chapters that would be left after coverage of this Lokpal as well, but allow me to complete this syllabus for 2020 prelim, and once this 2020 prelim is over, rest assured whatever chapters that has been left out, 5 or 6 chapter from Lakshmikant's 6th edition point of view, will be covering that as well. So if you are preparing for 2021, then you need not to worry, we'll be covering each and every chapter. So with this we'll be wrapping up. Once we have covered this Lokpal, we'll be completing this section of the Lakshmikant, and then we'll be moving to the next section of Lakshmikant. So with this information, let us move to the next slide and let us start discussing that what is going to be the scope of this video, how we have planned to cover this chapter on Lokpal. So as always, we will be raising this question, what is this Lokpal and why this body Lokpal has been created when we already have these institutions like CBI and CBC. What is the necessity of this Lokpal? Why this specialized organization named Lokpal has been created? Then we will be discussing the evolution of the Lokpal, whether Lokpal was created through this Lokpal Lokayukta Act 2013 or Indian system did have existence of this institution or any institution like Lokpal earlier as well. Then we will be discussing the selection process, the search committee, all these things will be covering, right? And thereafter the jurisdiction, function, power, working of the Lokpal. As part of working, right, we'll be spending around half an hour only on the discussion on this working of the Lokpal. And as always, there are 3 MCQ that has been appended for you to attempt into the last section of this video. Now without wasting time, let us move to the next slide and let us start discussing that what is this Lokpal or what is this Lokpal. So if I discuss the what aspect of the Lokpal, basic objective of the Lokpal, that is what is this Lokpal that you can see on the screen, this is a simply copy paste. The objective of this Lokpal is it is going to be apex integrity institution, and this body's mandate is to fight corruption and to ensure integrity into the public life. And this is the same definition, or this is the same objective that we had discussed. Rather, these 3 lines I have simply copy pasted from the Central Vigilance Commission. The same lines you will find behind what aspect of the Central Vigilance Commission. So why is it so? See, the Lokpal, the basic objective of the Lokpal is also same, that is the objective of CBI, and that is the objective of CVC, or that is the objective of ED, or many institutions that we do have in India, which is fighting this menace of corruption. So the same objective it is also going to fulfill, that is Lokpal is also going to fulfill or going to or at least attempt to eliminate corruption from the public life, especially focusing on the central government, because as far as the state government is concerned, right, they do have this Lokayukta. So at the union level you have this Lokpal, and at the state level you will have Lokayuktas, right? So Lokayukta will not be covering in this particular video. Our focus in this particular video will remain entirely on the Lokpal. However, if you want to trace the origin of Lokpal and Lokayukta in legal terms I am speaking about, so origin of both these institutions, at the union level you have Lokpal and at the state level you have this Lokayukta. So origin of all these 2 institutions can be traced from a common act, that is Lokpal and Lokayukta 2013. But one thing that you have to notice, that yes, Lokpal came into existence in India through this act, that is Lokpal and Lokayukta Act 2013. But as far as Lokayuktas are concerned, although the statutory status that Lokayukta is going to get in various states, right, it may be because of this act, that is Lokpal and but it does not mean that Lokayuktas were not as an institution, Lokayuktas were not present in any of the state. Rather, even before enaction of this act, even before legislation of this act by the parliament in 2013, in various states you had this presence of Lokayukta even before 2013. So that is one, although I had said that we will not be discussing Lokayukta in this video, but that is a basic difference between the Lokpal and Lokayukta. Although we started, when we will discuss the evolution of this Lokpal and Lokayukta, you will find that the discussion on having this institution called or ombudsman called this Lokpal, right, discussion has started way back from 1960 itself, but finally statutory status or in legal terms through a parliamentary act, right, this Lokpal as an institution came into existence only into 2013 itself. Even though, means although this act was passed, again as part of evolution, right, we will be discussing that even after enaction of this law, you will notice that no Lokpal was appointed for next 5 years. But that is not the point of this particular slide. We were supposed to discuss what and why aspect of the Lokpal. So let us have our focus on this aspect. So what aspect we already have understood, that it is this institution, like many other institutions like CBI, like ED, or many other parliamentary laws that government or many state laws that various government has passed. The basic objective of this institution is also going to be same, and that is to fight corruption. Now here to maintain the integrity into the public administration, primarily at the union level, right, because that point I already have pointed out that at the state level same law jobs will be done by the Lokayukta. So the two questions that we should be raising, so the first question is that why we have created this separate institution named Lokpal, right? If the objective of there are separate institutions like CBI or ED or police or judiciary that is dealing with the similar objective to eliminate corruption, why we have created another body? What is the necessity of this specialized organization when we already have another specialized organization to deal with the same objective? And the second question that we will be raising is that, okay, if you have created this body called a Lokpal to eliminate the corruption, to eradicate the corruption, and to ensure integrity into the public life, whether this Lokpal as an institution has been given that institutional autonomy, whether it has been given independence, that amount of independence, so that it can exercise control over all the public institutions. So that will be our, whether it would be able to, that amount of independence, that amount of autonomy that was absent. Means when we were discussing this CBI, we had talked into the second last slide. If you have watched our lecture into the second last slide, we had shown you that how this CBI has been subjected to the multiple control, multiple puncture center. You had this control of Ministry of Home Affairs, you had this administrative control of Department of Personnel and Training. Over the CBI we are talking about, you had this control of UPSC, you had many kind of control or many kind of ministry, many kind of department. This CBI, although it was an investigative agency and it has good, as far as investigation is concerned, as far as rather not investigation, prosecution is also concerned. One information regarding the CBI that had not been provided to you into that more than 1 hour of the lecture, and that information right now I am providing you about the CBI, that CBI, besides being a what you call investigating agency, right, it does have provision of special courts as well. And much like the civil court that we do have, like subordinate court, district court, then high court and Supreme Court, they also do have court, and they do follow this law of CRPC. So that is one information that is not related to, this information is not related to the Lokpal, but that is related to the CBI, and that should have been provided to you guys into the CBI lecture itself. But during the review I found that that information had not been provided to you guys. So that is one information that was regarding the CBI. Now coming to the Lokpal. So we were talking about that whether the second question that we had raised, that yes, many institutions like CBI and CVC, and while discussing these ills of these organizations, even regarding the central vigilance, see, the CBI was a executive body, right? What was the ills of this CBI and CVC? So CBI was a not a statutory body, it was an executive body, so it had all amount of central control. You have this government control, so we created this body. Rather, CVC was created much earlier, right? You had this CVC that had been created in around 1960s, right? And this institution has been given in 2003. This institution has already been given statutory status. But even though this institution whose purpose is to fight corruption, the purpose of CBI is also to fight corruption, right? So although it was an executive body and this is a statutory body, so it has been, means in terms of autonomy, if I talk about, so the autonomy that has been given to the CVC is more than the CBI. But even though this has been made a statutory body, it still is a advisory body, right? So the second question that we had raised into the Lokpal, that whether if these many organizations, we already have a specialized organization to fight the corruption, what additional power that is going to be extended to the Lokpal, that whatever else that CVC did have, or whatever else that CBI was, right, whatever reasoning that we had extended, what additional power that is going to be extended to the Lokpal that will ensure that yes, corruption will be eliminated or corruption will be eradicated. Whether they have been given that amount of institutional autonomy, whether that had been so into the CBI, we already have talked about that they did not have that institutional autonomy. They had that multiple puncture point, they have that multiple controls, right? CVC, although it is a statutory body, but still it did have only advisory function. It could not prosecute any erring official, any corrupt official. So whether this institution, into the second question that we will be raising, that whether Lokpal has been given some additional function on top of this, right? Because if you are not going to provide additional function, right, whatever power that CBI or whatever power that CVC has been extended, if you are going to create, okay, we agreed that okay, CBI could not fulfill its obligation, right, or fulfill its function because of some ills. And what was the ills? Because it is an executive body, it has control. Okay, CVC was also not able to fulfill the function. So if you are creating a new institution, that is Lokpal, right, so whether that institution would be, or whether it is just a duplication of institution, right, just to satiate the public anger, just to satiate a public demand, right, whether you are creating a new institution. And the reply will be affirmative. Reply will be that this institution is also, because you will notice that much like this CVC, this body is also going to be advisory only, although it will have certain additional power that this body, CVC and CBI did not have. But even those additional power of the Lokpal will also not ensure complete justice. When I am saying complete justice, so I am talking in terms of punishment, rewarding or conferring punishment to the corrupt official. It will also not have full power. So first of all, this Lokpal, although it has been, because it has been created by a parliamentary act, it is going to be a statutory body, much like the CVC. CVC was also a statutory body, right? What is the status of CBI? CBI is a executive body, right? So here we have raised, let us raise the first question, that why this despite having so many institutions, we do have police, right, we do have judiciary. Thereafter we created the job of the police and judiciary, besides other criminal function, right, besides fulfilling their obligation towards criminal justice function, the job of the basic elementary job of police and judiciary is also to fight corruption. If there is any case against any corrupt official, if somebody has asked any kind of bribe from some official, has sought any kind of bribe, I can go to the police, I can go to the judiciary, that so and so services were offered, right, by the government, and when I demanded those services from this concerned food officer or from this depot holder, right, he did not provide me those services, and he did not provide me those rations, so he happens to be corrupt, and you file the corruption case. So that was the very first institution at the very transactional level is the police and the judiciary. Then we created certain, okay, we agreed that okay, police is not that equipped because it does have multitude of function, right? So it is not an equipped organization to deal with what you call the corruption cases. So let us create, as far as money laundering or any kind of economic cases is concerned, right? Then we created this ED to tackle those kind of money laundering cases, right? You do have various parliamentary act like FERA and FEMA. So those cases will be, or those nature of cases where economy angle is concerned, you have this ED. Then certain specialized function was given to the CBI as well. So whatever cases that under the PCA, Prevention of Corruption Act, when we were discussing this CVC, there we had discussed that whatever cases that were being referred under the Prevention of Corruption Act by the to the CBI, or CBI independently as well can register these kind of cases, right, against the public sector bank, against the PSUs, right, against the government, central government employees, and CBI services can be obtained by the state as well. Then we studied about, we discussed the ills of the CBI, and then we studied about the CVC as well, Central Vigilance Commission as well. Now you have, means my point here is that when you do have these multitude of organizations dealing with the same subject, that is corruption, or to ensure integrity into the public life, you are bringing this new body. What should have been our approach? Our approach should have been that we should have, first of all, instead of creating these kind of institutions, right, instead of, we are not right now talking about the Lokpal, right, we are talking about that why in the first place you created these kind of institution, right. What you could have done is that you could have empowered this police. How you could have empowered this police? When I am saying you could have empowered, I am talking to the state, right, I am talking to the central government, I am talking to the state government. So what you could have done is that you could have empowered. Since 60 itself we are talking about the police reform. As part of police reform, we are talking that they should be given autonomy. They should, much like the CBI director who has been given 2 years of the fixed tenure, the DGP of various state, Director General of Police, as part of police reform I am talking about, DGP should also be given fixed tenure of 3 to 4 years. So that has been the recommendation. You have this editorial, if you come across any editorial from the Prakash Singh, he is a retired IPS officer. So from last 15 years, he is continuously contesting cases in Supreme Court on to this topic of what you call this police reform, right. He is suggesting Supreme Court to direct various, and Supreme Court rather on occasion has directed states as well, and it has sought report, but because these kind of decisions come under the policy domain, and policy making is job of state government and the central government, and that's why judiciary cannot overstep its limit, right. So whenever you see any article from the Prakash Singh, most likely it would be either on internal security or it would be on police reform. So what is the first approach that states, central government or state government could have taken is to empower this police through various police reform measure, that because this is going to be what kind of police reform. One example I already have given, but there are multiple dimensions to this police reform. Then as part of reform to the judiciary, what reform that judiciary, so there are many lakhs of backlog cases that judiciary is struggling with, right. So you could have increased the judges' strength in various kind of subordinate. Yes, at the Supreme Court level you already have increased the judges' strength from 30 to 33, we agree, but what about the most loaded what you call courts? The most loaded courts are these subordinate courts, right. So at the district level you should increase the number of benches, you should increase the number of judges, right. At the High Court level as well, you have various kind of vacancies that is not being filled, right. So judiciary should be capacitated, right. You do have judges who are working for 17 hours, 18 hours, first 8 to 9 hours, means at the transactional level you might be seeing that they are working only on this 8 or 9 hours, but you will find that even when they go to the home, even when they reach to their quarters, you will find that they do have these typewriter, and for 3 or 4 continuous hours their typewriters keep typing the judgments, right? Whatever judgment you would have seen that the judgment of particular case was of 600 pages or 700 pages. You would have heard that advocates asking into the various film or media news channels that we have yet not read that judgment, let us read all the judgments. So why those judgment takes time? Because those judgments are of 600 or 700 pages. So those 600 or 700 pages has to be written once they have reached their home, and that do take hell lot of time, right? So in that case, if the judiciary's backlog has to be created, the number of judges or number of subordinate courts primarily means in Supreme Court, I already told you that they do have means enough number of judges, but the condition of subordinate courts and condition of high court is very poor as far as judges strength is concerned. When you do have this overstretched judiciary, you cannot expect what you call means generally 5 to 7 minutes is the average time that is given. I am not talking about the Supreme Court, but means I am talking about the subordinate court at the generally 5 to 7 minutes of the hearing is given to a particular case. Sometimes cases are wrapped up within 2 to 3 minutes. It is because of the backlog pressure, it is because of the case load pressure, right? So what state can do in this direction? So my whole point is that rather than creating every time you do have a new problem, right, rather than creating multiple organization or one additional organization, what state, the approach of state should have been, rather than creating even means okay, we talked about this police and judiciary, rather than creating this CBC, what goes into, if you can from executive status, if you give this CBI, right, this was the part of our reform that we had extended, that we had given you while covering this CBI itself, that what reform is required into the CBI. So there we had discussed that this body should be kept on par with CAG, their removal method, their security of tenure, rather it should be given a constitutional status, and if constitutional status cannot be granted, at least statutory status, rather than letting this CBI function under this generalist organization, that is CVC, Central Vigilance Commission for PCA cases, right? Give it a statutory status, its budget that is being controlled by this DOPT, right? That again acts as a puncture point, right? They should get a approved budget or assured budget by the parliament rather than getting it approved from the executive. So these kind of autonomy, if you start giving to an investigating agency, you will not have necessity of this additional organization named Lokpal, right? So that is the first question. But you should not be taking that this Lokpal is going to be completely useless organization, right? Or it is going to be a same entity much like CBI or CVC when it comes to fighting the corruption. There is one basic difference between the CBI, CBI, CVC and the Lokpal, and the basic difference I'll let you know. Let me cover this jurisdiction of this organization named Lokpal. Once we have covered jurisdiction of this Lokpal onto the next slide, then I'll let you know the basic difference between the CBI. Yes, the purpose of the CBI or CVC or ED or the Lokpal, that is the new institution, right? So the basic purpose or the basic or the elementary objective of these organization is going to be same, that is to fight corruption. But there is one basic difference between the objective of this CBI or the clientele of the CBI, means the people it is going to target for their corruption. And the basic difference would be, see, as far as means you would have heard that CBI taking the case of ex-chief ministers, right? The most recent case is of late Jayalalitha, right? She has died. I perhaps should not have been taking her name, but the most of late case of any that CBI has taken against any ex-chief minister is of of this late Jayalalitha. Thereafter you had this Lalu Prasad, he is also into that food fodder scam, right? So there has been many instances where CBI has taken case against these kind of high profile case against these ex-chief ministers or incumbent chief minister as well. But you would have never heard that CBI going up to, despite being a premier police agency, despite being premier or apex central police, right? You would not have heard the CBI has taken case against the prime minister as well, incumbent as well well as ex-prime minister. Against ex-prime minister, again you can cite one or two rare example, but as far as incumbent, have you ever heard that any investigating agency or any state established agency, I am saying state, when I am saying state here, I am not only meaning this Rajasthan, or I am talking about both the governments, right? So have you ever heard that any state established agency, any agency that has been created by the state itself, right, it has taken case against any incumbent prime minister, right? So this Lokpal is going, rather the primary focus, means the basic objective, the elementary objective of the CBI, CVC or the Lokpal as well. Let us add another circle, that is Lokpal, right? So the basic objective is same, that is fight corruption, but the clientele that this Lokpal is going to target, besides whatever clientele that CBI or whatever targets or whatever jurisdiction that CBI does have, besides those jurisdiction, or and one more thing here as well, that although CBI has never been denied that it can never take any case of corruption against the prime minister, it has never, means it has not been mentioned into the mandate of CBI that CBI cannot take, but it has never been envisioned, right? You cannot, we have been a colonial state, right? And here prime minister or the chief minister in state is considered king, right? We have been ruled by the monarch, and as a citizen, right, and this is a symbol of maturing democracy. Means so far or of late, means until 10 years ago or until 15 years ago, right, nobody could have imagined that even prime minister, if he has been corrupt, right, nobody can think that even a case can be filed against the prime minister as well, right? But this institution, and that's why perhaps despite not having clearly mentioned into the CBI mandate that it cannot take cases against prime minister, despite no clear provision, CBI has not, because it had never been imagined, right? We cannot imagine, rather perhaps we educated elite class of 1% of the population can perhaps imagine, right? We can be idealistic that law, we can talk about very easily Article 14 and everything, but then when it comes to implementation, or when you go to the other 99% of the people, then no, prime minister should not be, he is directly elected, right? He is democratically, and how can you arrest prime minister, because they cannot even imagine, right? So that is the thing. But here the very starting of this Lokpal is going to focus from, yes, the primary focus will remain same, that is tackling corruption from the public life, but the objective, the first objective would be that its clientele or its jurisdiction is going to over the incumbent prime minister, the incumbent union minister. As far as union minister is concerned, against ex-union minister or against incumbent union minister as well, you would have seen the cases being filed. But the primary focus, as I already said, that the CBI was focusing primarily on to the chief ministers, and even on the chief minister it could lay their hands or jurisdiction, because only when at the central level, right, you had this opposite party ruling, at the state level as well you had this opposite party ruling, otherwise CBI could never have taken. You would have seen cases whenever the same ideological party has at the central level and at the state level, and if the CBI has filed cases during the previous government against any particular chief minister, you would have seen the cases where cases has been withdrawn by the CBI, same CBI organization, because there has been change of the government at the central level. So here I'll again come back to this point, that is Lokpal, the basic objective or the primary objective of the Lokpal, or the primary emphasis of the Lokpal is on the political executive. Not besides, means it will be taking cases of corruption against the central government employees as well. That was the function of the CBI as well, but besides that function, besides that jurisdiction, its primary focus would be on the political executive. That is prime minister, ex-prime minister as well as incumbent prime minister and the union minister. So let us see, let us have a look on this jurisdiction, this whatever text that you saw on this screen, right, that is why this 100th agency to fight corruption. Why can't we strengthen the existing legal framework, bridge the loopholes? Why can't we make CBI more autonomous? The same thing that we had raised, right? Why can't CVC be given more teeth? Why can't we free police from the executive control? Why not to implement long debated and much needed police reform? Why not to fill the backlog? So whatever that discussion that we had, these things has been put up on into the textual format. So let us have a look on the jurisdiction, and then we'll let you know that why this Lokpal means. The common objective is same, that is tackling corruption, but what is the difference between the jurisdiction of the CBI and the jurisdiction of this organization, that is Lokpal. So here if you see the jurisdiction, so the very first line is past and present Prime Minister, Union Ministers and Member of Parliament, right? And this is something that is going to differentiate this organization Lokpal from the CBI, the erstwhile organizations like CBI, CVC or ED, right? Although again I will be pointing out that in the CBI mandate it has never been written that it cannot take case against the Prime Minister, incumbent Prime Minister, but it is just that because of the political immaturity among electorates, right, it has, because we never envisioned that even these organizations that has been established by the state would be taking on the state itself, right? We never envisioned, and that's why you had this new institution, that is Lokpal, we had to create, and to specifically mention that what Lokpal will be doing means besides these things, that is the mandate of CBI as well. It has been clearly here mentioned that it will be taking on if there is any allegation of corruption, right? Although some safeguard has been given, because against the Prime Minister there may be many allegations, right, driven by the political motive, driven by this ideological reason, driven by any kind of vendetta politics. So those safeguard has been added. Whenever Lokpal will be taking cases against the incumbent Prime Minister, right, there are certain safeguard that has been provided, and that we'll be discussing when we'll discuss the working mechanism of this Lokpal. There we'll discuss that how, if there is any case that may against the Prime Minister, any allegation that may spoil international relations, those kind of cases will not be taken by this Lokpal. So those safeguard has been provided. We are right now discussing this jurisdiction, right? So which kind of cases or which kind of people this Lokpal can target, or Lokpal can take cases against which all people. So past and present Prime Minister, Union Ministers and Member of Parliament. Then Group A, Group B, Group C, Group D officers and other central government employee, right? Society, any kind of society, any kind of trust, any agency that has been substantially financed by the government of India. They are existing, whichever society that we are talking about that has been financially, substantially financed by the government of India, even their prior secretaries or their director who has retired right now, even those secretary and even those directors के खिलाफ भी cases लिए जा सकते हैं. Any person who is or who has been secretary, director or manager or of a body or society controlled by government of India. So I hope these 4 points you will have clarity on. Then any NGO that is receiving more than a fixed amount, and that is fixed amount is 1 crore annually from the government of India. If you are an NGO, if you are running NGO, and if you are receiving more than 1 crore of donation from the government of India, and if there is any allegation of that falls under Prevention of Corruption Act 1988, then this Lokpal will have jurisdiction over your NGO as well. Then any NGO or any agency that takes foreign contribution from foreign countries like under FCRA, and their contribution or the contribution from the foreign annually exceeds more than 10 lakh, then over that agency as well Lokpal will have jurisdiction, right? Any person who is involved in any kind of abatement of bribe, right? If he is abetting, if he is inspiring, if he is compelling, right, anybody to take bribe or anybody to give bribe, even in that situation Lokpal will have jurisdiction, because that case will be falling under Prevention of Corruption Act 1988. So here 2 questions that we have responded. The first question was that why this new institution has been created when we already had this multitude of organization, right, tackling the same objective. So why this new body has been created, right? So the answer to that question, the first question, that this body has been created because this body will primarily, besides taking on to the central government employee, besides taking into the clientele that was already being looked by the CBI and CBC, it has been clearly mentioned into the mandate of this new organization, that is Lokpal, that it will be taking corruption cases against incumbent prime minister, incumbent union minister and incumbent member of parliament, something that has not been so far envisioned. So that is one difference, that why this new organization. Yes, there is duplicity of effort, right, because as far as central government, but this thing was very necessary. So that was the first question. What was our second question? Whether this organization would be able to fulfill all the goals or not, right? So that question will be responded once we have covered whole of this video, right? Once you have understood the working mechanism, right, the practical aspect of this Lokpal functioning, then you will have clarity on whether this organization would really be able to fulfill all these functions or not, whether they have enough resources at their disposal, right, whether they have been given that institutional autonomy. So as far as institutional autonomy, let me just give you one allusion, and I'm talking about allusion, not illusion, right? So let me just give you an indication. See, even this body has not been made constitutional. This is not a constitutional body, this is just a statutory body, right? So whether a statutory body would be able to fulfill its function in an independent manner or not, that we'll see, right? We'll look at how they are appointed, because appointment, again, the way of appointment or the nature of appointment also ensures the independent. We'll see the budget, how budget of this organization is approved, whether these people can be reappointed or not, because reappointment prospects also impacts the functioning, the independent functioning of any organization. So those kind of things we'll be looking into, and thereafter we'll try to just see that pattern we already have discussed, right, that how the appointment method, how the possibility or prospect of reappointment, how these budgets, how these salary provision, how these tenures, how the removal method impacts, and any organization, even if I do not point out, right, you should have developed the capacity, right, because this pattern we have been discussing when we started our discussion on the constitutional bodies, right? So we look on all these parameters, appointment method, removal method, whether they have been given security of tenure or not. So these kind, and then we try to judge how independent that organization is. So that we'll be doing into this Lokpal section as well. So your second question, whether the Lokpal would be able to fulfill the stated goals, right, that will be responded once we have covered whole of this video. So I hope two things, that is why this body, what and why aspect of this Lokpal would have been responded, and another thing that would have been responded is the jurisdiction, right? So this jurisdiction, although we covered as part of why aspect of the Lokpal, but this jurisdiction as well, right, you will have clarity on, right, what kind of NGO, what kind of agencies, or what all people, right, group A, group B, group C, right, which all people will have jurisdiction. So this jurisdiction as well into the next section of this video will not be repeating, right? So I hope you will have clarity on at least these two slides and these 2 points. Now we are moving to the next slide. One thing, besides general vision of eradicating menace of corruption from public life, the emphasis of this Lokpal is tackling corruption in higher echelons of the power corridor, and that is political, executive and high ranking officials. So this point we already have covered. Now we are moving to the next slide, and this jurisdiction we already have covered. However, Prime Minister's function, whenever a case will be taken by the Lokpal in relation to the incumbent Prime Minister, I am talking about, if there is any allegation of corruption that can spoil or that is in realm of international relation, then those kind of cases will not be entertained by the Lokpal. If there is anything that is related, if there is any allegation of corruption and those function in which level of corruption has been alleged, right, if that function deals with the security, again the case against the Prime Minister will not be taken, or if there is any allegation of corruption against the Prime Minister when he has taken any decision into the relation of atomic energy or space, even those kind of cases will. So these are the 3 safeguard or 4 safeguard that has been provided to the incumbent prime minister, right? Shall remain outside the real or outside the jurisdiction of this Lokpal. I hope you will have clarity onto the Lokpal's jurisdiction and certain exception that has been provided, right? Prime Minister especially, right? Prime Minister has been provided those exception as well. You will have clarity on. Now we are again okay. As far as certain exemption has been provided to the MPs, member of parliament as well, and member of parliament can't be held responsible for anything that they have said into the parliament or any manner of voting, right, that they have done into the parliament. So even if there is any allegation that a member of parliament voted into the inside parliament in certain manner because he has been provided certain amount of financial backing or certain inducement, right, even then a case under this Prevention of Corruption Act 1988 cannot be registered by the Lokpal. So whatever privileges that member of parliament has been provided under Article 105, right, that will remain protected. Lokpal cannot do. So those kind of protection will remain. Those kind of privileges that has been defined for the member of parliament under Article 105, those will remain there. What was the article that is dealing with the privileges of member of legislative assembly or the state legislature members? What was the article? Article 194, right? So this is the thing. So I hope now the jurisdiction and the exception as well you will have clarity on. Now we are moving to the next slide to discuss the evolution of the Lokpal in India. So the evolution of Lokpal, if I talk about, so Lokpal, although as I already told you into the introductory section of this video itself, that the Lokpal as a body has been created in India by Lokpal and Lokayukta Act 2013, and the first date it became effective from 16th of January 2014, right? It was passed into 2013 December, and then it was signed by the president on the 1st Jan 2014, and it became, because it was published into the government gazette on this day, so from this day it became, that is 16th Jan 2014, it became effective, right? So as this point has already been pointed out, that this Lokpal as an institution came into existence into India in 2014 by this Lokpal and Lokayukta Act 2013, but the discussion on having or the necessity of this institution started being felt from 1960 itself. I am not getting into the traces, that how does it traces its origin from the Scandinavian country. What are those Scandinavian countries, right? So you do have in Europe, you do have these 3 countries that is collectively called Scandinavian country, NFS countries as well. I'm not going to point out that what are those countries or which country I am referring as NFS, right? So you can, if you want to trace the origin of this ombudsman or institution called Lokpal, although means Lokpal is a generic name that has been given to the, so the terminology is the ombudsman, right? And by this and this ombudsman is what investigate the terminology, the meaning of this ombudsman is investigating agency. Investigating agency, and to this ombudsman, right, in different part of the world, in different country, it will be known by different name, right? In India we do have this Lokpal, we know it as Lokpal, and into Indian states we know it as name of Lokyukta. So it traces its origin from 17th century, not 17th, 18th century, and it all started from the first country into the world was Sweden. So it all started from Sweden, and finally you will notice that after independence, right, Britishers had also started, but they started this having this ombudsman not in India but from in their own country, and thereafter after independence, because we are more interested into the Indian context, right, so it started the discussion on this, having this ombudsman like Lokpal and Lokyukta. This discussion started into the parliament by this man called Ashok Kumar Sen, who happened to be law minister into the 1960s, and he expressed his desire, or he expressed that there should be some institution on those lines of the ombudsman, right? But he did not, mind you, that he did not use this word, that is Lokpal and Lokyukta. For the first time in 1963, you will notice that this man called L.M. Singhvi, these two names, Ashok Kumar, but here the scene was not there, right? Ashok Kumar Mehta. In this particular topic it is seen, but into the Panchayati Raj institution as well, into the 73rd and 74th, the evolution when we were talking about of 73rd and 74th constitution. So here you do have these kind of various committee, Ashok Kumar Mehta committee, Ashok Mehta committee, then L.M. Singhvi committee, Baldev committee, right? So these kind of committees we already have talked. So here coming back again to this particular topic, Ashok Kumar Sen started this discussion into the parliament, and he happened to be the law minister. Then you have this L.M. Singhvi, as I already pointed out that Ashok Kumar did not use these two words, that is Lokpal and Lokyukta. You have this man, this L.M. Singhvi, who is going to word Lokyukta and Lokapal, right? In Sanskrit you can trace Lok means people and Pala, protector, right? So the people's protector, in realm of corruption, right, the people's protector will be known as Lokapala, and similarly Lokyukta at the state level. So L.M. Singhvi is going to use this word for the first time in India, that is Lokpal, into the Indian context. As I already pointed out that the generic name is the ombudsman, the standard name, not generic name, the standard name of such institution across the world is ombudsman. In India, to this ombudsman we are going to describe as Lokpal and Lokyukta. Then you will notice that you had this first administrative reform commission, and in 1966 this commission is also going to point out that yes, we need some institution called Lokpal and Lokyukta to ensure the executive accountability. Then you will find that in 2002 you had this National Commission on Review of Working of Constitution, right? This National Commission on Review and Working of Commission we have studied earlier as well, which was led by or which was chaired by this M.N. Venkachalaiah, and this M.N. Venkachalaiah committee we have to study in later part of this polity as well, right? So what kind of recommendation that he had given for the proper functioning of the constitution, or what overhaul that it has recommended for the constitution, in what all area we should be amending our constitution. So this his commission or his recommendation we have to study earlier. So in his recommendation, or as part of his recommendation, or as part of his study onto this National Commission on Review of Working of Constitution, he has recommended that yes, there should be some institution called Administrative Reform Commission, right? So much like Administrative Reform Commission, he also recommended that we need to have an institution called Lokyukta and Lokpala. But one thing that you will notice, that whichever body or whichever institution or whichever committee that will be sitting to point out that yes, Lokpal and Lokyukta is necessary, they will be putting Prime Minister as well. And most of the discussion, see, we have reached from starting 1960 and we have reached to 2002. You will notice that it is not that the parliament will not do anything. Parliament rather between 1960 to 2011, you will notice, will make 8 attempts towards having this institution, that is Lokpal and Lokyukta. But most of the time, sometime it will fail into the Lok Sabha, sometime Lok Sabha will dissolve, sometime it would not be able to cross the Rajya Sabha. And the most contentious point behind creation, this Lokpal would have been established much earlier, from in 1970 or 1980 itself. But the contention, this was the contention, that whether Prime Minister should be brought under the jurisdiction of the Lokpal or not. So that is one contention that ensured that this institution is not established, or this institution does not come into existence from 1960 to 2030. And at the end of the day, see, this is a general observation not related to this Lokpal or Lokyukta. See, as long as there is one say in Indian system or Indian society ki jab tak, and that say is in Hindi, and you will have to understand ki jab tak bachcha chillata nahi hai, right, maa bhi doodh nahi pilati hai, and that is a reality. So jab tak electorate, unless electorate starts shouting, unless electorate voters start demanding, there would be no reform, right? You start political class has always responded, and that is the beauty, and that you will have to understand, and that will come through the analytical. See, political class is always ready to give you whatever you demand, right? It's not that they do have any kind of inhibition, right? They do not have any kind of inhibition. You start demanding, and when I am saying you start demanding, I am not talking about 1% of the elite who does not go to vote. I am talking about those 60% or 65% of the people who are not that aware, but they do go to the vote. So the day they start demanding, because their requirement is limited, their requirement is not this fundamental right, freedom to speech and freedom. This liberal kind of idea is the demand of liberal people like we, and we do not go to vote, right? So it is the demand when these people, 60 to 65% of the people who really go to the vote into the parliamentary election or state, when they will start demanding, their demand is limited only to this roti kapda makan, and that's why even today into the election manifesto it is the roti kapda makan, right? Agar hum usse aage nahi badh paye hain, if we cannot go beyond these freebies, it is because that we never demanded with that energy or with that enthusiasm these kind of reform. So by 2013, when this debates into the media really started, right, you had this Anna movement, you will notice in 2011, 2012, and when this will gain momentum, you will finally find that the political class will respond, they will have this institution, right? So that was one point that is not related to the Lokpal, but that is just a general analysis, and that is mine analysis on when this Lokpal will come into the existence. So I was talking about this 2002, and in 2002 you have this M.N. Venkachalaya who will also point out that yes, we need to have a Lokpal like institution. Finally, in 2005 as well, you will have, in 2005 you will have this second administrative reform commission, and rather this second administrative reform commission, again that is not related to the Lokpal, the information that I am going to provide. So this continued working from 2005, and it continued submitting its report until 2011. So when I am saying 2005 for this second administrative reform commission, this is not correct information. It may have been somewhere in 2006 or 2007, but exact date has not been, exact year has not been mentioned. The only thing that has been mentioned, the second administrative reform commission has also said that or expressed the necessity of this institution called Lokpal. So year I have just mentioned from my own assessment, right? This year has not been mentioned into any of the book or any of the sources that is available on the internet. So second administrative reform commission as well expressed the desire or expressed the necessity of having such institution called Lokpal and Lokyukta. Then you will notice that finally in 2013, right, so all these years we already have studied. In 2013 you will have this Anna Hazare led India Against Corruption movement, which will gain momentum, media will give wide coverage, people will be agitated, and after that agitation, Congress government hurriedly in 2013 December itself, it will be passing this Lokpal and Lokayukta Act 2013, which will get President assent on 1st January 2014, and it will be effective from the mid of January 2014. But 2013 you passed the act, from 2014 that act came into effect, but you will notice that until 2019 there would be no establishment of the Lokpal. Again, means you pass the act into 2013, 6 years the next government is going to take, and the first Lokpal was instituted. The 8-member committee plus 1 chairman has been instituted only last year. Again, why this delay? Because of the same contentious point that Prime Minister, whether Prime Minister, although means from this, in this Lokpal, this provision has already been made that yes, even incumbent Prime Minister, provided that certain safeguard into certain areas, even incumbent Prime Minister will remain under the jurisdiction of this Lokpal and Lokyukta Act. But means central government at the central level, even after passage of this act, kept delaying on one pretext or another, that whatever delay that they could add into institution of this Lokpal, again until the Supreme Court reprimanded the government, right? The government of the day did not institute this institution of Lokpal, and the politics that they did take, when we will see the selection, that who are the people, the selection recommendation will go through a committee. So on that committee you did not have this leader of opposition into the Lok Sabha, right? And the government made a point that because we do in Lok Sabha we do not have this leader of opposition, and on the selection panel of this Lokpal, leader of opposition should be there, and that's why we are not having the meeting of this selection committee to choose this Lokpal. Finally, in 2016 or 17, right, after the Supreme Court's intervention, this Lokpal and Lokyukta Act in 2016 will be amended to include a new word that in absence of recognized leader of opposition into the Lok Sabha, the leader or the representative of the largest party as well can be part of that selection committee. So in 2016 this act will be amended to include this point, right, that in absence of recognized leader of opposition into the Lok Sabha, you can have leader of largest party on that selection panel. So even after that amendment in 2016, 3 more years this government will take to appoint the first Lokpal. So right now the position is that yes, we do have 8 member and 1 chairman Lokpal. So that composition we will discuss. So I hope on this evolution and what years it has gone through. So on the evolution part you will have an idea. Now we are moving to next slide to discuss the provisions of the Lokpal and Lokyukta Act 2013. So if I talk about the provisions, various provisions of Lokpal and Lokyukta Act. So provisions of the Lokpal and Lokyukta Act primarily deals with the composition, structure, features, then selection panel, search committee, powers and duties of the Lokpal and Lokyukta, timelines of the investigation, and which kind of association. So on these points we'll be discussing. The provisions has not been put up into those lined or textual format, right? We have, when we'll be discussing composition of this Lokpal and Lokyukta Act 2013, right, we'll be taking that animated images, then structure as well while discussing that animated images would be there. Similarly, discussing the feature, selection panel and search committee, all these things will be dealt in a animated manner, right? So now we are moving to, so we'll be discussing the composition, structure, feature one by one from the next slide. Let us move to the next slide and let us start discussing the composition of the Lokpal. So if I talk about the composition of the Lokpal, it is going to be 2-layered organization. At the top you will have chairperson, and at the bottom you will have these maximum of 8 members. So here if you consider, here if you see, if you notice, the word is the maximum of the 8 members. So it can have, it can be 7-member body, it can be 6-member body, it can be 5-member, whatever, right? It is ultimately on this precedent that how many. So current strength, if I talk about current strength or current body or current Lokpal that has been instituted in 2019, that is having 1 chairperson and 8 members. So the maximum sanctioned strength is of 8 members. So it is operating right now with the 1 chairperson and the 8 members. So that is regarding the composition of this Lokpal. If I talk about the breakup, the categorization of this 8-member body, right, it has been categorized at the 2 level. The first level is that half of the member body, currently it is a 8-member body, so half of the member should be from the judicial or should be the judicial member. Whether that what will be the judicial members, whether they should be belonging to the subordinate court, whether they should be belonging to the High Court or Supreme Court, that discussion we will have, but half of the members should be of the judicial background. Then half of the members should be belong to any of these categories, that is SC, ST or OBC or minority or the woman, right? So one point again, if you notice, see, if any member who happens to be of judicial background, coincidentally if he also happens to belong to any particular community, that is SC, ST, or if he happen or she happen to be woman, right? So that counting will be counted into this category as well. So that person will belong to this category as well, and he will be belonging to this category as well. So I hope this further categorization or the 2-level categorization of this 8 members you will have clarity on. Now we are moving to next slide to discuss the qualification, which all person, if a person has to be appointed as a chairperson of the Lokpal, what qualification he or she should have, or what qualification a person should have to be appointed as member of the Lokpal. So let us move to the next slide and let us start discussing the qualification. So if I talk about the qualification, a person to be appointed as chairperson of the Lokpal, he should be retired Chief Justice of India or retired Supreme Court judge. So a sitting member of Supreme Court or a sitting CJI, Chief Justice of India, cannot be appointed as chairperson. So former Supreme Court Chief Justice of India or a former Supreme Court judge, right, not the High Court judge, right. So a High Court judge or a High Court Chief Justice of India, right, he or she cannot be appointed as chairperson. So that clarity I hope you will have regarding the chairperson. If I talk about the members, so if I talk, see, in members you do have these two categorization, right. So if I talk about half of the members should be judicial members, so whether those judicial members should belong to the Supreme Court or High Court or the District Court. So let us have that thing, right. So the judicial, half of the judicial member, that is 4 member, should be either former Supreme Court judge. Former, when I am saying, I am talking about the retired judges, right. So the people who does belong to this judicial member, or who will be put, the 4 people means considering that 8-member body right now we do have of Lokpal. So 4 members should be of the judicial member, 4 members should be judicial member. So those should be either former judge of Supreme Court or former judge of High Court. So again, there is no provision of sitting judges to be appointed as members. So that was about this categorization. Now another, minimum of half of the members should be belonging to any of these community, right. So does just being belonging to SC community or ST community or OBC or minority or women will qualify to be appointed as member of this member of this Lokpal? The answer is no. Besides this qualification, see, it's just that for empowerment of these particular weaker section, this option has been put, right. But besides this, they should possess certain other qualification as well. And what are those other qualifications? So they should have 25 years of track record or track record of excellent service into any of these fields. So what kind of those fields are there? So minimum of 25 years of experience into the matters of anti-corruption policy, or into the public administration, or into the vigilance, into the finance, into what you call this insurance, or into banking, or into law. So any person who happens to belong to any of these category, any of these 4 or 5 category, and have at least 25 years of experience into any of these fields, then he or she can be appointed as members of this Lokpal. So I hope the qualification criteria you will have clarity on. Now we are moving to the next slide to discuss the disqualification criteria. So as far as so far whatever qualification that we have studied for NHRC or SHRC, we have studied only the qualification criteria. There was no such thing that who are the people who cannot be appointed as members of NHRC or SHRC. But here we do have certain criteria or certain class of people who cannot be appointed. If they fall into that particular class, they cannot be appointed as members of this Lokpal. So who are these people? So if any person does happen to be member of parliament, or if a person does happen to be member of legislative assembly, then he or she cannot be appointed as member, right? Because that would be the conflict of interest there will be. Because see, what is the mandate of this Lokpal? So the mandate of Lokpal is to investigate the corruption against the very same people. So very same people, or the people belonging to their own fraternity, cannot be appointed as member. Thereafter, if you are a Panchayati Raj institution member or urban local body member, in that case as well, that person cannot be appointed as members of this Lokpal. Then if a person has been convicted, does not matter what had been the length of conviction, whether it was 1 year or 2 years, right? that does not matter. But if a person has been convicted, he or she, if a person has been holding office of profit, even that person cannot be appointed as members of the Lokpal. If a person has been removed on the disciplinary ground from the public service, even then that person cannot be appointed. Any person who is pursuing any kind of business or any kind of profession, even that person. But however, there is one caveat into this section, that if a person is conducting or pursuing any kind of business or any kind of employment, if he chooses to resign, right, from that profession or surrender that business into favor of somebody else, then a concession can be given and that person can be appointed, provided the condition that he fulfills, that yes, he do have 25 years of experience, minimum of 25 years of experience in all those fields that we just talked about. So these are the things, these are category of people, right, those cannot be appointed as members of the Lokpal. I hope you will have clarity on these points, right. So these are the people who cannot. If I talk about the selection criteria, selection process of the Lokpal, so if you remember, starting when we started this discussion on extra constitutional body, right, we had something called selection committee, right. It was not, means president although was the final authority, he was the appointing authority, but he was not receiving recommendation from the council of minister, right, as like UPSC, like CAG, right, it was the council of minister that was deciding that who will be the person who will be appointed. Means the qualification criteria of course was there, right, but who will ultimately will be appointed by the president, right, that was being decided by the council of minister, and that is the government of the day. But starting this extra constitutional body, be it NHRC, SHRC, Central Information Commission, State Information Commission, Central Vigilance Commission, so those kind of body did have this selection committee consisting of certain people, right, that we already have discussed. So that selection committee was, or selection panel was recommending to the president that who all people should be appointed chairperson or the members of that particular body. And then, so similarly here as well, into the Lokpal section as well, you do have this selection committee, and selection committee here will be consisting of Prime Minister, Lok Sabha Speaker, Chief Justice of India, Leader of Opposition. So those kind of things we'll have a discussion on. But besides this, unlike this NHRC which had just selection panel, or unlike this SHRC or CIC which just had selection panel, you do have these two additional structure as well, that is Search Committee and Department of Personnel and Training. So the appointment of the Lokpal member or chairperson is much like going to be the UPSC exam, right. So in UPSC exam, first you have this preliminary examination, then you have mains examination, and if you get to clear this mains examination, then you will have to face this interview board, and if interview board gets your name into the PDF, then the president is going to get you that appointment letter, right, that lovely letter. So the same process will be opted into the Lokpal as well, except that it is not the UPSC that is going to conduct examination here. Here you do have these three structures. So first of all, you will have this Department of Personal Training, which will be performing this first screening process, that is preliminary examination. Thereafter, search committee will be preparing that mains examination questions, and then you have this selection committee which will be conducting this interview, and ultimately eventually this president who will be appointing that person as Lokpal member or Lokpal chairperson. Now how we have drawn already the analogy, now how this process actually works, let us see. So if I talk about starting from the selection committee will have all these members, that is Prime Minister, it will be chairperson, the chairperson of this committee, that is selection committee will be Prime Minister. Then you will have two people from the Lok Sabha, that is Lok Sabha Speaker and Leader of Opposition from the Lok Sabha. Now here on the Leader of Opposition, Lok Sabha, you have this star, and the star sign is because in 2016 you had this amendment. In 2013, when this Lokpal and Lokyukta Act had been passed in 2013, you did not have this star. Here the option was Leader of Opposition from the Lok Sabha. But in 2014, that is 16th Lok Sabha and 17th, even current Lok Sabha does not have a recognized Leader of Opposition. And under this garb, actually, you will notice that from 2014 to because this act came into effect, Lokpal and Lokyukta Act came into force in 2014, but you will notice that it will take for the current government around 5 years to appoint, because in 2019 the first Lokpal will be constituted. So a 5-year gap. Now why there was this 5-year gap? So the first 2 years the government kept advancing this idea that because in the selection panel you have this provision of leader of opposition, and because we do not have in Lok Sabha, we do not have this leader of opposition, so we cannot complete this selection panel. And when we do not have this selection panel, how can we recommend president regarding the appointment or regarding the institution of this body called Lokpal? So that was the idea that was advanced by the government of the day until 2016, but then Supreme Court is going to intervene, right? And Supreme Court will say this thing. So what the Supreme Court is going to talk? So Supreme Court will say that no, means any one person's absence from the panel, be it speaker of, suppose on the day when selection panel is going to sit to decide that which people should be recommended, on that day if any particular person is not absent, that will not invalidate the decision. And on that day, if this committee is taking any kind of decision, right, that this member should be appointed, this person should be appointed as member, that will not, that absence of a particular member on that particular day will not invalidate the decision of the committee, right? So that paved the way that even if leader of opposition is not absent, that will not invalidate if the committee is taking any kind of decision in the absence of leader of opposition, that will not invalidate the decision of the selection committee. Besides this, finally in 2016 you will notice that this Lokpal and Lokyukta Act will be amended by the government itself, and this star will be added, recognizing the fact that if Lok Sabha, in absence of recognized leader of the Lok Sabha, right, leader of opposition into the Lok Sabha, right, if leader of opposition is not there, in that case leader of largest single party, right, can be part of this panel. So that amendment happened in 2016, and even after that there was this 3-year that was taken by the government to institute the first Lok Sabha. And the current position, right now the situation is that yes, we do have a Lokpal that is consisting of 1 chairperson and 8 members. So that was about the selection panel, right? Now the thing is that okay, selection panel you do have, but where this selection panel will receive its input from, that who are the people who it should consider, right? Because the process of this selection panel is to conduct the interview, but somebody will conduct this mains examination. So this mains examination of this UPSC or for these members will be conducted. And when I am saying mains examination, it is not exactly the mains examination of your, it is just a analogy, right? So that this mains examination here in this process will be conducted by the search committee. But here the interesting thing is that the very body, that is search committee, right, which will conduct this mains examination, will be instituted on the direction of this selection committee itself. And this search committee is going to be at least 8-member body, and this 8-member body, as I said, I am repeating this, that this 8-member body will be constituted or will be instituted on the recommendation of the selection committee itself, right? Thereafter, now again, the search committee also has to receive input from somewhere. So that input to the search committee will be provided by this Department of Personnel and Training. So whatever people you may have at any given time against 2 or 3 vacancy or against 8 vacancy onto this Lokpal, right? At any time there may be 3 or 4,000 eligible people, right? So out of available talent pool, it is the Department of Personnel and Training's duty that it will do the first screening, that is conducting the preliminary examination, and after this preliminary examination has been conducted by the Department of Personnel and Training, it will be giving some list to this 8-member search committee, and thereafter, after conducting the mains examination, right, this search committee will be providing a list to this selection committee, and based on that list, right, they will do some kind of scrutinization, and after that a final report will be forwarded to the president, right? And president finally, based on the recommendation by this selection panel, will be appointing members or the chairperson, right? Here again, one common thing between UPSC exam and to the selection process, you will notice that the search committee, whenever against one particular vacancy, suppose there are 2 vacancies into this members section, so against one particular vacancy or against 2, the ratio that will be forwarded to the selection panel by the search committee will be in order of 1:3. That's almost same ratio that UPSC means forward to the interview. So if requirement is of 900 people by the UPSC for the final selection, then you would be seeing, you would be noticing that for around 2700 or 3000 people will be called in for the interview. Same ratio, that is 1:3 or 3.1, or sometime it may be 1:2.9, right? So but that factual information is not necessary, that is not going to be asked into the exam, right? So that is about the selection process of this Lokpal, right? And you do have these 2 new bodies, that is search committee, Department of Personnel and Training, Supreme Court. Absence of any one member, that point we already have discussed, so we are not focusing on the selection process of the Lokpal. Now if I talk about the term and removal method, so term and the removal, the term if I discuss about, so term of both member and chairperson is going to be 5 years and 70 years, whichever is earlier, right? As far as chairperson, if I talk about the removal process, so removal process, see, chairperson and members of this Lokpal will be removed by a common process, and the common process has been laid down in the very act through which this body has been created. So what will be the common process? So these people will be removed by the president, finally by the president, but there is a procedure, right? First of all, let us discuss what will be the ground on which these people, the members or the chairperson of the Lokpal, can be removed. So those people will be removed on ground, and that is misbehavior, right? Now what is the meaning of this misbehavior has already been explained, means the meaning has already been defined into the constitution itself, and that meaning has already been communicated to you guys into the previous lecture. So right now I am not into explanation of this misbehavior, so on that ground. But ultimately, who will be deciding that whether a person has fallen or any member or chairperson has? See, when president will be forwarding the report, right? So president may forward, president will not be acting independently while taking that decision, right? President's reference to the Supreme Court. So here in that case, again a new point, that who will be deciding? So president cannot decide that whether a person, he can just suggest that yes, from my perception or from Council of Ministers perception, a particular member has fallen into this category, but president is not going to be the competent authority, because if president is given power, right, so his decision, because he does not take independent decision, his decision will be influenced by Council of Ministers consideration, and Council of Ministers are ultimately a political body, right, political people. So they may want to get rid of any uncomfortable member into this Lokpal, right, and they can have their biased opinion. So ultimately this decision will be decided by the Supreme Court. So whenever president finds that any particular member has fallen into this category, then he will be referring that case to the Supreme Court, and whatever observation that Supreme Court will take, based on that, president may choose to remove that particular member or chairperson. Now there are 3 ways on which, following which, president will be referring the case to the Supreme Court, either on his own wisdom or on the basis of petition that has been filed by any citizen and president is satisfied, right? If any citizen files a petition that a particular member has fallen into that category and president is satisfied. So the 2 condition in this line, that you file the petition, because see, if president is not, president satisfaction in this point is necessary, otherwise there would be n number of complaint, n number of petition by any particular citizen or 10,000 people on every given day, right, frivolous kind of complaints. So that is the second condition, and the third condition is that on basis of a petition signed by 100 member of Parliament. So here the member of Parliament does have a role, not the member of Parliament does have a role, not the Parliament as such, right? So this case will not be going. As soon 100 member of Parliament does sign the petition that a particular member should be removed on the ground of misbehavior, then in that case president will have to refer that case to the Supreme Court. Supreme Court ultimately will be advising the president, and president may issue order of removal of member or chairperson. So that was about the removal method, or that is how this removal of members or chairperson can be performed. Now we are moving to the next slide to discuss the reappointment, the prospect of reappointment. So here, instead of mentioning that exactly means these people, members can be, whether they can be reappointed or not, right, this detailed explanation has been given into this act. So after one person who has been what you call member or chairperson, once he has get off from that post, he cannot be given any kind of diplomatic position, any kind of diplomatic assignment by the government of the day. That is, he cannot be made ambassador, or he cannot be made councillor. Then he cannot be given any post of administrator into any of the union territory, or he cannot be appointed governor, or he cannot be given any kind of constitutional post like in UPSC or CAG. He cannot be appointed by the government of the day. Then he cannot contest any kind of election for next 5 years. So that cooling off period of 5 years has been extended. Again, why this cooling off period of 5 years has been extended? Just to ensure that even in last year, his decisions, last year of as his member or chairperson, right, his decisions are not influenced by any kind of inducements or any kind of threats that the government may offer, right? So he cannot, and when I am saying he cannot contest any kind of election for next 5 years after seizing the member of Lokpal, so that provision, so that election means general election, the assembly election. Besides that, he cannot contest even the Panchayati Raj institutions election or urban local bodies election. Besides that, even he cannot contest president and vice president's election. So these points you can add into your notes, right? Then any other office he cannot assume under the government of India, right? So you can see effectively he cannot, although the word has not been mentioned that he cannot assume any kind of assignment under the government of India, or he cannot be reappointed under the government. That word has not been used, right? But here the detailed explanation has been given that these subcategorization, under these subcategorization, he cannot be given any kind of job, or he cannot do these kind of things. So after reappointment, let us move to the next slide and let us start discussing the working mechanism of this Lokpal. So as far as working of this Lokpal is concerned, we will be taking two approaches. On this slide particularly, we will be discussing the general information, right? The basic information, that how on the receipt of the complaint from any organization or any person regarding the people on which this Lokpal does have jurisdiction, how these process works, and thereafter from next slides onward, right, we'll be taking one step on each slide and we'll be having a detailed explanation, right? So on this slide, let us have a general explanation. So in any case, see, on which people this Lokpal did have jurisdiction. So you had this central government employee of category A, category B, category C, category D. So these kind of employee. Besides that, you do have prime minister, you have this union ministers, you have member of parliament. So these kind of people you do have. So if any complaint is received by any person against any of the person whom this Lokpal does have jurisdiction, and that case is falling under this Prevention of Corruption Act. So this is very important, this Prevention of Corruption Act 1988, right? So if there any of the activities is falling under this this Prevention of Corruption Act 1988, then that complaint will be entertained, right? A preliminary inquiry on receipt of this complaint, right? A preliminary inquiry will be conducted. Now, who will be conducting this preliminary inquiry? So, see, as far as Lokpal is concerned, Lokpal, although does have civil court's power, right? But besides this civil court, it does have its own small investigating agency. I am saying investigating agency as well, and that investigating agency is called inquiry wing, right? But again, this inquiry wing is not experts like CBI, or they are not expert like Central Vigilance Commission. So their role is primarily limited only to conducting the preliminary inquiry as well. So this preliminary inquiry can be conducted by their own inquiry wing as well, or if the Lokpal chooses to transfer this function as well, it can be transferred. The conduction of this preliminary inquiry can be done by the chief CBI or CVC or ED, right, depending on what organization this Lokpal chooses, right? Once the preliminary inquiry has, so this preliminary inquiry has to be completed within 90 days. Here this 60 days is incorrect. So has to be completed by these agency in 90 days, and thereafter these agency, be it inquiry wing of this Lokpal itself or CBI or ED or CVO, right, they'll be submitting that report, and based on the findings in the report, the preliminary report, right, Lokpal will be deciding whether that case should be closed or it needs to be detailed examination. If this case is closed, then okay. If the Lokpal decides that no further scrutiny is needed in this particular case, then for detailed examination, right, the same agency, either the same agency, so if CBI had conducted this preliminary inquiry, then same agency can be given responsibility to conduct the detailed examination of the case as well. After the detailed examination, again there is this timeline that okay, for the preliminary examination we already have studied 90 days. For the main examination or for the detailed examination, you have this 180 days, and that can be extended by another 180 days. So that detailed examination or that nuanced study will be doing into the next slide. So after that, it will be submitting the final report to this Lokpal, and based on that final report, this Lokpal will be taking the call that whether that report should be forwarded to the department through which this category of employees belong, and department should be directed to prosecute that particular person, to transfer, to terminate the services depending on the severity, or whether that agency which has investigated that should be directed that you go and file the case against particular official or particular union minister or prime minister, incumbent prime minister, right, into the appropriate court. So that call will be taken by the bench of Lokpal, right, not a chairperson or not a particular member, but that decision will be taken by a bench of Lokpal, right. So I hope you will have an idea, general idea on the working of the Lokpal. Now we'll take one step each time on every slide, and we'll be doing this detailed scrutiny. So if I talk about the first step, that is on receipt of complaint, right. So if a complaint is received against incumbent prime minister or incumbent union minister, then what does happen, what Lokpal will be doing. So see, those 4 areas we already have studies regarding, in which the prime minister has been given the safeguard, that was in international relation, that was in relation to the atomic energy space, right. So in those areas, if a case of corruption or if allegation is made against the prime minister, right, this Lokpal will not be entertaining that case, because if it is impacting, if any decision was taken in relation to the security, that okay, in J&K these many people, these many arms and ammunition should be sent, or in Ladakh area these many arms and ammunition, or these many fighter jets should be, and if you are if I as a citizen or if anybody is leveling any kind of allegation corruption, right, so that details cannot be shared during the investigation. Those kind of details cannot be shared with you guys or any kind of investigating agency, and that will be not, those charges may not be proved, or prime minister may not come with those kind of proofs, right. So in those areas, of course, if any kind of international obligation is concerned, again the details cannot be divulged from the government side. So that's why in those 4 areas that concession has been extended to the prime minister. Now if any allegation is made by any person besides those 4 areas, except those 4 areas, even then there are certain safeguard that has been granted to the prime minister in that case, except those 4 areas, right, that has been mentioned into the act, right. If against incumbent prime minister any charges are leveled, in that case you will notice that first of all, full strength of the Lokpal, 8 members and 1 chairman will be sitting, right, the full bench size will be sitting, and those people will be taking the decision, looking into the merit of case, whether that case should be pursued or not, right. So 1 + 8 people will be sitting, and those once 2/3 of the total member, if they decide that yes, the case should be pursued, then only against the prime minister this Lokpal is going to conduct the investigation. So that is a second safeguard that has been provided to the prime minister. If I talk about the union minister, if any case is received against union cabinet minister, in that case 3 bench member, 3 member bench will be sitting, and then they will be deciding that whether case should be taken, whether case does have merit or not, right? And these three member bench will be deciding that case should be pursued or not. So these are two protection that has been given to the Prime Minister and the Union Minister. So I hope to avoid, and that has been given, protection has been ensured, that to avoid filing of frivolous cases, Lokpal does not entertain any anonymous case, right? And that is going to be one drawback of the Lokpal as well, that if you want to disclose any kind of information without providing your name, you cannot do that, right? You will have to provide, you will have to declare your name, right? So that was about this first step, that what concession the Prime Minister or Union Minister has been given. Now we are moving to the next step, and that is regarding the preliminary inquiry. So as I already have pointed out, that the preliminary inquiry can be conducted by the Lokpal, its own inquiry wing as well, or it can be sent to any specialized organization like CBI, CVC, CVO or CVD. Lokpal may choose to conduct preliminary inquiry through its own inquiry wing, or can refer to here as well. Here one additional power that Lokpal does get, that suppose Lokpal has transferred a particular case to the CBI or CVO or CVC or ED, in that case over the officials who are investigating the case. So suppose CBI as an organization dedicated that okay, this group of 5 officials are going to conduct investigation on that this particular case that has been referred by the Lokpal. Now the Lokpal will have complete control over these 4 or 5 people. If the CBI in midway want to transfer 2 or 3 official or 1 official from this investigating responsibility, CBI cannot do that without Lokpal's concurrence. So I hope you will have, during investigation of the referred cases, Lokpal does have complete control over the investigating officials. Agencies, that is CBI or CVC or ED, cannot transfer the official without Lokpal's concurrence. So I hope the inquiry stage you will have clarity on. Now there are certain set timelines, okay? Besides that, there are certain additional information. Let us discuss that before discussing the timelines. So see, during the this investigation, when investigation is ongoing, right, Lokpal does have few additional power. First of all, that if Lokpal perceives that again, suppose a particular IAS officer allegation had been made that okay, that particular IAS officer while holding that particular post, he obtained 100 crores. Out of that 100 crores, he purchased of 56 crore. This is the bungalow that he purchased, right? And rest of 40 or 45 crore he has deposited in this particular account. So during the investigation, during the pending investigation, what this Lokpal can do, that Lokpal can order the concerned agency for the confiscation or the attachment of that property as well, and he or she, that Lokpal, can get that account seized as well. Lokpal means directly cannot do that, but it can order the concerned agency to what you call, to attach that property and to seize that account. So that is one power. The second power that this Lokpal does have, that it can order, again it will not do it directly, but it will order the concerned authority to transfer or to suspend that particular official pending the inquiry. Till the inquiry goes on, he or she can be suspended, not directly of course by the Lokpal, but by the concerned department on the direction of the Lokpal. It can also order the transfer and suspension and search, seizure, confiscation. So those kind of powers it does have. The next thing, if I talk about those, so there are clear timelines that has been mentioned for the preliminary inquiry, for the main inquiry, and for the trial. So what are those timelines? So for 90 days preliminary inquiry can be conducted. One extension, however, if the case is complex, then to that particular agency for conducting the preliminary inquiry, for the completing the preliminary inquiry, one extension of another 90 days can be given to that particular agency. So that was about the preliminary inquiry timeline. If I talk about the main inquiry, during the detailed scrutiny, that should be completed by that particular agency into 180 days. If they cannot complete it in 180 days, then again extension of 180 days can be given. However, it is not mentioned that how many extension can be given for the detailed scrutiny, whether only 1 or 2. Here into the preliminary examination, this term has been mentioned that one extension of 90 days can be given, but here in one time only 180 days extension can be given. It has not been mentioned that how many extension can be given. As far as trial is concerned, so trials is to be completed within 365 days, that is within 1 year. Here as well it has been mentioned that at the trial stage as well one extension of 365 days can be given. So, and while performing all these roles that we discussed, right, while performing all these roles, Lokpal does have power as a civil court, right, civil court, right. So that was, so we have completed it until here, and one thing that you have to clear, it is 90 days. This is a scanned document from my own notes. So that was about this working of the Lokpal. There are few aspects that are still pending. If the case is regarding, so this point you can read, right, I am not going to read this. This is a simple line. During the preliminary investigation, okay, so during the preliminary stage or the detailed stage, right, the alleged official or alleged member of parliament or union minister is given chance that he can defend his or her case. So I hope that clarity as well you will have regarding while performing all these tasks, Lokpal will have powers of the civil court. That point as well we have discussed. Now, once agencies submits its preliminary investigation, bench of Lokpal, right, not the chairperson or any particular member, right, based on the findings of the report. So once report has been submitted, right, so based on findings of the report, right, it is the Lokpal which will be deciding that whether persecution of that person, right, should happen or not. If you remember the provisions of Prevention of Corruption Act, before this Lokpal, what did it said that if any particular official has been alleged that he has indulged into corruption, then in that case the inquiring agency will have to go to the competent authority and will have to take permission whether inquiry against that alleged corruption can take place or not. But here the Lokpal will be deciding whether the prosecution based on the preliminary inquiry, right, that bench of Lokpal will be deciding whether that particular person against which means the detailed examination should be conducted or not. So here the Lokpal, after the institution of the Lokpal has become the competent authority, means you need not to go to the government. If there is any case, any allegation against any particular official under this PCA, Prevention of Corruption Act 1988, now it is not the government directly, means the inquiring agency, that is CBI, CVC or CVO, right. If the case is coming to this agency, if the case has come from this Lokpal, in that case whether that particular, after the preliminary investigation, whether the detailed examination they will be subjected, these corrupt official will be subjected to not, right, that will not be decided by the government of the day, but that will be decided, that would be approved. The competent authority in this case will be Lokpal, that will be approved by the Lokpal and not by the government. So competent authority for the approval of prosecution. So these kind of, see, my thing is that I need not to read all these things. The essence I will let you know, the things I will make you understand, these things you can read, otherwise it will be duplicate. So whatever that is written here, the same thing I have repeated here itself, right. Depending on the severity, of course, it may suggest either department for the prosecution, right. Prosecution means what? Transfer, suspension or termination, right, depending on the severity, whether the services should be terminated or he should be transferred or he should be suspended for 6 months or 8 months, depending on the severity, this body will be. Now one thing that you will notice, that this body, that is Lokpal as well, means it is not directly prosecuting these official, these corrupt official, even if it is sure after the investigation, the detail that this particular official is guilty, right, they will either have to suggest the court, right, the case will go into the court or case will go to the department, right. So the second question that we have raised, that whether this organization is going to get hold of the independence or not. So this organization is also going to be advisory body, much like Central Vigilance Commission, but one or two additional power that it does have regarding the transfer, that it can order that particular department or government for the suspension or for the termination of the services, right? And it can get their properties obtained from the wrongful means, or the accounts obtained from the wrongful means, they can be confiscated. So those kind of additional power it does have. And the primary client layer, or the primary jurisdiction that it does have, is over the incumbent prime minister as well. So that is one difference. If I talk about the limitations of the Lokpal, so it does not, first of all, this point we already have discussed, that if due to fear of you being pointed out, right, if you do not want to name yourself while making complaint, right, so it does not matter what kind of material evidence you do have produced into that letter that you want to send to the Lokpal. If you want to be anonymous, that option has not, your case will not be taken. Does not matter how strong argument or how strong material proof that you have extended, right, your case will not be taken against that particular official or particular union minister or prime minister. Legal support to the accused official is given, right. Cases older than 7 years cannot be entertained by this organization. So that is again a main point, right. So in NHRC, right, this period was only 1 year, right. So 1 year, more than 1 year old case cannot be taken by the NHRC. But the domain of this NHRC is not to deal with the corruption. It is just a analogy, right. Lokpal cannot take suo motu cognizance. So that is also one limitation of the Lokpal. Then provisions of punishment for false or motivated complaints. So if suppose you filed a complaint and the basis of the premise of complaint was genuine, but by any means, due to collusion by that government official with any kind of mean, if by implying the muscle power or by employing financial power, if that official made sure that he comes out innocent from the process of investigation, then charges can be leveled against you, right. So that again discourages people for not filing complaint again in these kind of cases. It can't directly prosecute the culprit, advisory body that we already have discussed into the previous slide. So with this, we are wrapping up this lecture with these 3 MCQ. Lokpal we have discussed, Lokyukta we did not discuss. Lokyukta is going to be a small topic. If you want, right, I can release a video of 15 to 20 minutes. The only difference, see, the origin Lokyukta, the difference between this Lokpal and Lokyukta is that Lokyukta will have power over the state official, whatever power that we have discussed of the Lokpal over the union level, similar power they will be enjoying in relation to the state, right. And the another difference is the Lokyukta as an institution existed in India even before enaction of this law, that is Lokyukta and Lokpal and Lokayukta Act 2013. You had states like Odisha or Karnataka which already had Lokyukta. So those are the basic difference, right, and that is going to be a small video of 10 minutes. So if you ask, right, if you can read, if you can manage, you can read it. If you want, I can release another video, but except that we are wrapping up this section of the Lakshmikant. We'll come up with the next section in next 2 or 3 days. So I'm leaving you with these 2 or 3 MCQ, right, first, second and the third MCQ. So these are the 3 MCQ that I expect you to attempt until I come up with the next lecture. Till then, bye bye.